Yes, Ms. Easton.
Thank you, Chair, and thank you, Commissioners. This afternoon, I'm very pleased that we have a panel of advocates and experts from Women with Disability Australia. Our panel members have given their affirmations and I'll briefly introduce them. So Carolyn Frohmader joins us, Marley Hermans joins us, and Tess Moodie. Right, Chair, I just think you might not be, okay, you're off mute.
Yes. Thank you. Ms. Frohmader, Ms. Moodie, Ms. Hermans, thank you very much indeed, both for coming to the Royal Commission in Hobart, even though in Sydney we can't actually see you on the screen at the moment, but I'm sure you will emerge very shortly. We're also very grateful to WWDA for all of the very, very considerable assistance you've provided in assisting in the preparations for this hearing. We're very grateful for those contributions which have made for a very important hearing and a hearing that has covered a very large range of issues. So we want to thank you both for your attendance at this panel and also for everything you've done to assist the hearing that has been held this week in Hobart and in Brisbane. Yes, thank you. I still can't see the panellists. I don't know if others are in the same position.
Well, I think we might just press on, and I hope, Chair, that that you'll be able to see.
Now it's been remedied. Thank you very much. Now we can, at least I can see you. I hope everybody else can as well. Thank you.
I might start by just making some introductory comments. So Women with Disability Australia, I'm going to refer to as WIDA, if that's okay with you, is a national disabled persons organisation, a DPO, and a National Women's Alliance member. And you represent girls, women, feminine identifying and non-binary people with all types of disability in Australia. The key purpose of WIDA is to promote and advance the human rights and freedoms of women, girls, feminine identifying and non-binary people with disability. WIDA uses the term women and girls with disability on this understanding that this term is inclusive of, supportive of women and girls with disability, along with feminine identifying and non-binary people with disability in Australia. WIDA's goal is to be a national voice for the rights of women and girls with disability and a national force to improve the safety, lives, life chances of women and girls with disability. You represent more than 2 million disabled women, girls, feminine identifying and non-binary people in Australia. You have affiliate organisations and networks of women with disability in most states and territories in Australia. And you're also internationally recognised for your global leadership in advancing the human rights of women and girls with disability. And as a DPO, WIDA is managed and run by women with disability for women and girls with disability. I hope that gives the commissioners and those following this session a sense of what you do and your reach. Now, I was going to start with some formal introductions, and it might be helpful for the commissioners and those following to know from each of you a little bit about what your role is at WIDA. It doesn't have to be long. Ms. Frohmader, we have met you in public hearing 17.1 back in October, and you and Ndis spoke to us about sexual violence, but really looking at issues concerning sexual and reproductive rights for women and girls with disability. So a warm welcome back to you.
Thank you.
This time we're in person. I said to you, I can't promise that the fire alarm won't go off again, but you won't have to walk down 16 flights of stairs that Dr. Steele had to do mid-hearing, and still managed to be on the line and engaged in giving evidence while that was happening. So shall we use first names?
Yes, please.
So Caroline, over to you.
Good afternoon, everyone. Thank you for having us. This is an extraordinary opportunity for us. I have been the Executive Director of WWDA for nearly 25 years. And so there was a lot of that 25 years where I was had no staff. Now I feel a little bit spoiled because we have a few staff, which is fantastic. Yes, so that's my role.
Marley?
Yes, hello, thank you for having me as well. My name is Marley Hermans and I am a Policy and Project Officer at WWDA. So that means that I work across both some of our projects that are targeted towards our members, including the WWDA Lead project, as well as in our policy work, particularly as a newly established and funded National Women's Alliance by the federal government.
Thank you, Tess.
Hi, thank you for having me. I'm Tess Moodie. I'm a fairly recent addition to WWDA, but feel like I've been here for 10 years already because it just feels so wonderful to be part of the organisation. I'm also a Policy and Project Officer, predominantly working on our Disability Royal Commission work and engagement, but more recently pitching in and helping out with the Women's Alliance work.
Thank you.
So, yeah.
You wanted to start before we have the discussion to give an acknowledgement of country. Who would like to do that? Marley?
Yes. So before we begin, WWDA would like to acknowledge the Muwinina peoples of the Ngunnawal Nation of Truwana Lutruwita, the traditional owners and custodians of Napalina, the land upon which we're meeting today. We pay our respects to the ancestors and the elders of this place, both past and present, and we also acknowledge and pay our respects to any First Nations people appearing at this hearing and to those who may be joining through the live stream. Violence against women with disability will never be fully addressed in this place without first reckoning with systemic racism and ongoing colonial oppression. WWDA will always stand in solidarity with First Nations women with disabilities. Today, every WWDA staff member providing evidence to the Royal Commission is also a victim survivor of gender-based violence. Like many of our colleagues who work in advocacy or the gender-based violence sector, we know that embedding our lived experience in prevention, early intervention, and responses to gender-based violence is vital to ensuring the principle of nothing about us without us. We acknowledge past advocates, activists, and change makers who have come before us, including WWDA's founders, and those who continue to tirelessly work towards ensuring women, girls, feminine identifying and non-binary people with disabilities can live their lives free from violence. In acknowledgement of Trans Day of Visibility today, we draw particular attention to and celebrate the leadership of trans disabled people and that leadership that they continue to demonstrate in our community. Finally, WWDA extends our respect to the many women, girls, and gender diverse people with disability who have lost their lives as a result of violence, and to those who continue to live with lifelong impairments as a direct result of the violence perpetrated against them. Sitting in front of me right now is a photo of my mum, Julie. My mum was a victim survivor, having experienced multiple intersecting and ongoing forms of violence throughout her life in a range of settings, including hospitals and a disability group home. My mum was murdered by a healthcare system that decided her life as a disabled woman had no value. Those who perpetrated this violence took away her right to speak, as they do every day to countless other women and girls with disability. The elders and mentors around me have always taught me to bring a human face to our advocacy and struggles for justice. Today, as we sit in what can often be a cold and clinical setting, let my mum, Julie, serve as that human face. Tess, Carolyn, and I are not alone as we sit here today at this bench, because we carry with us my mum's memory and the memory of every other disabled victim survivor in here with us.
Thank you, Marley. Condolences for your loss. we've heard this week about the strength of mothers, grandmothers, sisters, and as Commissioner Mason said yesterday, that notion of sisterhood doesn't necessarily have to be the blood sisters, but it can be the unity that women bring to supporting each other. So welcome, Julie, and I'm very pleased your mum has joined you on the panel in spirit, and that we've also can see her. So thank you, Marley, for that. I want to start by asking you about WWDA's work and advocacy that's relevant to this hearing. Our focus on this hearing is women and girls who experience violence and abuse in family, domestic settings, and also sexual violence. WWDA's work extends into a wide range of areas touching on women and girls, but this hearing has got a particular focus. So Caroline, would you like to speak briefly about the history of WWDA's work advocating for the rights of women and girls with disability to be safe from all forms of violence?
Yes, thank you. I'm conscious that we don't have a lot of time and we have a lot of things to get through. So I wanted to speak somewhat briefly to this. I guess for those who don't know much about our organisation, we were formally incorporated in 1995, but operated as an unfunded network within a then national peak disability organisation. One of the reasons that our organisation came to be was because back in those times, most of the peak disability organisations were run by men, and the issues that women with disability wanted to speak about were ignored and trivialised. So initially, we just started off as just a very small group of disabled women who came together to give each other support. And we have grown a very lot bigger since then. But even back then, the right to live free from all forms of violence and to sexual and reproductive rights were the two most pressing issues that women with disability wanted to speak about and wanted to be on the agenda. And unfortunately, things haven't really changed. It doesn't, it doesn't matter how many times we ask our members to identify their priority issues. It doesn't matter the ways we ask the questions, how we ask the questions. The right to live free from all forms of violence is always the priority issue. And sexual and reproductive rights and freedoms comes pretty close with that. I think it's outside the scope of this hearing to talk about all the work that WWDA has done over a very long time in this space. I think, our organisation has undertaken research, published books. We have written more submissions than I would ever be able to count to governments, to regulatory bodies, to parliamentary inquiries. We've given evidence as witnesses to parliamentary and Senate inquiries. We've fought actually to be included in national advisory structures on disability rights and also on gender equality. I think over the last 3 decades, we've unapologetically forced our way into the mainstream women's movement and also to be better recognised within the disability rights movement as well. We have fought for over our history and we continue to fight for basic recognition, rights and respect. So we're accredited with the United Nations. We have special consultative status, which means that we can actually engage and support the work of the United Nations in this space as well. We've undertaken a lot of critically acclaimed national projects and also international projects. We've won national awards for our work in working to prevent violence against women and girls with disability. We've provided a number of detailed, evidence-based, very rigorous submissions to this Disability Royal Commission.
You have.
And we'll be providing more. And I also need to say that we will also be providing submissions where there are no issues papers. And one that we are close to finalising is specifically on sexual and reproductive rights. So I think that it's critical that this Royal Commission, a once in a lifetime opportunity that many of us and many who came before us have fought for over a long time, understands fundamentally that violence against us doesn't stop at the door. And this brings us to the scope of this hearing. Whilst I understand that the focus is on family, domestic and sexual violence, there are some very important things we need to say up front. So first of all, how do we define domestic settings? How do we define family? How do we define family violence in the context of women and girls with disability? So is a domestic setting understood as a house with a door? Is family understood as family of origin or family of choice? Is domestic and family violence understood to mean violence between essentially spousal and or intimate partners?
Can I jump in there, because that's a topic that I want to ask you about as we go on in looking at some of those definitions.
Exactly. So I'm going to skip through there because I'm just about to say we're going to speak about that more. But I think I need to make it very clear that for many of us, our domestic setting can indeed be a typical home with a door, but it can also be a group home. A licensed or unlicensed boarding house, a hostel, a prison, a tent, a semi-supported accommodation facility, a respite centre, aged care facility, hospital, just to name a few. But it can also be the street. It can be a park bench. So I think that we will talk later about the many forms of gender-based violence we experience. And so I hope that gives a bit of a sense of how our organisation perceives family and domestic violence.
So we've got to take a broad approach, and we have to really think about where women will be and where there is that risk in terms of sexual violence or family and domestic violence.
Yeah, but violence against women and girls should never depend on where they live.
Yeah.
Ever. Violence against women and girls is violence against women and girls. And to put a hierarchy on forms of violence in the context of women and girls with disability is problematic.
Right, I want to turn to human rights, and particularly drawing on international human rights conventions. As you're aware, the Royal Commission conducted its public hearing 18, and that was to examine how the Convention on the Rights of Persons with Disabilities, the CRPD, are applied in Australia. How is it implemented? And how important it is to have those human rights frameworks in our thinking around policy, development of laws and practice. So the CRPD does make reference to women and girls with disability, and there's also a general comment published by the committee. The Royal Commissioners have heard about the concept of cross-cutting articles in the CRPD, but your work is not limited to the CRPD, and you've shown that we need to look at a suite of human rights. When we're talking about women and girls, it's also drawing on the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, but also looking at other, what might be called the mainstream conventions. So the, Torture Convention, Caroline, do you
allowed to
want to talk
interrupt?
about, yeah,
Oh, okay.
go. You can ask the questions today, we'll swap. But my question for you is, taking a human rights approach, how does WWDA incorporate a human rights approach into your work? But what should we be looking at when we think about analysing and thinking about policies and practices in Australia?
Okay, so when we talk about, well, first of all, as you know, Australia is a signatory to 7 international human rights treaties and also has endorsed the Declaration on the Rights of Indigenous Peoples in 2009. Those international human rights treaties that we are a party to are not meant to be viewed in isolation. They're actually meant to be looked at and considered as a suite, a holistic package, if you like.
Sometimes the international law language is interdependent, interrelated, and indivisible.
That's
so we
right.
hear that language in international law.
So they're not mutually exclusive. So each one of these international human rights treaties that we are a signatory to, or a party to, each of them have obligations on Australia around reducing gender-based violence and also promoting disability rights. And so, and the concluding observations that come from the monitoring of Australia's performance under those international human rights treaties that we're a party to, there is an expectation that they are to be implemented. So in the domestic setting. And so, you know, it's like, as I said, those recommendations are expected to be implemented. So I want to give just an example of, I know that this Royal Commission is framed essentially by the Convention on the Rights of Persons with Disability, and that's critically important. It is an international human rights, intersectional human rights treaty. But for example, 6 out of the 7 treaty monitoring bodies of the 7 treaties that we're signatory to, for the last 18 years, have made very clear and specific recommendations to us, successive Australian governments, about the need to enact national law to prohibit forced sterilisation. I could, you know, go on about that, but I won't. And so, so it's not just the CRPD. Of course, that monitoring body has made that recommendation many times, but the committee that oversees the Convention Against Torture, I'll just use the short term if that's all right, has made, again, very strong recommendations around this. And so it's not just about looking at the CRPD and what it says we need to improve on. It's about looking at the recommendations from all those international human rights treaties, because, as I said, we have international human rights obligations under all of those 7. And hopefully soon, the Declaration on the Rights of Indigenous Peoples as well. Is that enough?
That is, yeah, that's fine. But I might ask Marley, because one of the issues is to understand multi-layered experiences or intersectionality. So I wanted to ask you about, how does the human rights approach address intersectionality or a multi-layered experience for women and girls with disability?
Yeah, I also don't want to get, I guess, too tied up in definitions, but I think it is worth defining intersectionality, because it is quite a common term that's used in mainstream feminist movement and also increasingly in public policy. And I think that there isn't a consistent understanding of what intersectionality is. So I just wanted to kind of briefly, you know, give a little bit of context that intersectionality was theorised by a Black scholar named Kimberly Crenshaw in 1989. Intersectionality, it grew out of Black feminist voices who'd been making this analysis for decades, if not hundreds of years. And so it's a tool that's used to, I guess, reveal and transform the interconnectedness of the ways that power and oppression work for people. So I know that Crenshaw, when she first theorized intersectionality as a concept, said that intersectionality reveals the conceptual limitations of single issue analyses. And as you can tell, that's very important for women and girls with disabilities, because we're not only oppressed on the basis of our gender, but also on the basis of our disability, and for many of us too, on the basis of our race and many different other parts of our personhood. So yeah, for women and girls with disabilities, intersectionality is really important because it serves to reveal the really grievous human rights violations that we're subjected to, and that I'm sure we'll talk more about today, not only on the basis of our gender, but on the basis of our disability. So it's a good tool, I guess, to understand how ableism and sexism aren't separate drivers of violence. They actually compound one another. And so we often experience gendered ableist violence, which is a different form of violence than, say, men with disabilities would experience. And the importance of intersectionality as a conceptual framework is that I think it challenges the way that Australian law and public policy attempts to really neatly compartmentalize different forms of discrimination like sexism and ableism, rather than recognizing the complex interplay between systems of oppression and power structures. So again, really critically, intersectional analysis serves to demonstrate compounding oppression for specific communities of women and girls with disabilities. For example, again, specific forms of violence that First Nations women with disabilities face in the colony, where First Nations women with disabilities are subjected to not only racism and ableism, but sexism as well. And that results in very specific forms of violence. So if we look at the context of forced sterilisation, if we look at how forced sterilisation has a very eugenicist history behind it, and consider that in the context of Australia as a settler colony, I think intersectionality is a quite useful tool to understand that. But unfortunately, most states, including Australia, don't recognise or really adequately address at all intersectional discrimination and its aggravating or compounding effects within human rights implementation. So often equality and anti-discrimination laws and provisions categorise identity and require each protected characteristic or each part of your identity or personhood to be dealt with in isolation. So this type of approach, I think we can all agree, is quite divorced from our own experiences as humans. I can't divorce my gender from my race, from my disability, from any of those aspects of myself. And yeah, in some jurisdictions, for example, victims and survivors of discrimination and violence can only bring a complaint of discrimination with respect to one ground, because intersectional discrimination is not provided for in the law. So for decades, WWDA has advocated for an intersectional human rights approach, urging both the Commonwealth as well as state and territory governments to embed, and I mean embed, intersectionality, not silo, not have 1 or 2 pages on intersectionality, but embed intersectionality within anti-discrimination law and all, I guess, legislative implementation of UN human rights treaties and instruments Australia is a signatory to. Because as Carolyn touched on before, human rights treaties and instruments like the CRPD, like CEDAW, like UNDRIP, they were never designed to be considered in isolation from one another, and they need to be viewed and implemented in tandem in order to fully protect the rights of cohorts like women and girls with disabilities, who, as we are aware, are frequently subjected to violence and abuse based on intersection of experiences of oppression. And women and girls with disabilities deserve the right to address and prevent violence on the basis of these specific forms of violence, rather than having to choose or prioritise one part of our identity over the other.
Okay. Tess, can I ask you that in the case of women and girls with disability who experience violence and abuse in their families or domestic settings, how does a human rights approach help us to understand the causes of violence and abuse? Do you want to take that question?
Yeah, sure. So before we talk about the causes or the drivers of violence, we need to really just place responsibility where it predominantly lays, and that is with the perpetrator. It's a perpetrator's choice to use violence. When it comes down to the drivers, understanding these causes and drivers can improve the way that we identify risk and respond to violence. However, this doesn't lessen the abuser's responsibility for their choices. Like Marley said, the main root cause of violence against women, whether they have a disability or not, is gender inequality. And gender equality is a fundamental human rights principle that underpins every major international human rights instrument. Gender drivers, I won't go into too much depth, but the gender drivers are mostly condoning of violence against women, the men's control of decision making and limiting women's independence in life, the rigid gender stereotypes that we see in society, and the male peer relations and cultures of masculinity that emphasise aggression, dominance or control. And like what Marley said, in addition to gender inequality, for women with disability, ableism compounds this violence against women, but it's also a driver in itself. So it's interconnected, but also can be separate. Recently, Our Watch released a resource called Changing the Landscape, which WWDA was part of consulting and contributing to. And that really unpacks that combination of the ableist and the gendered inequality drivers.
Just can I jump in there? That document is available online. So
It
if people
is.
want to have a look at that, they can search that up.
It's on Our Watch's website. So ableist drivers are the negative stereotypes about people with disability, accepting or normalising violence, disrespect and discrimination against people with disabilities, controlling their decision making, limiting their independence, and also social segregation and exclusion. So segregation in itself facilitates the use of violence, abuse and exploitation as well. So gender inequality and ableism intersect and compound to create this landscape in which women and girls with disability have violence perpetrated against them. And in some cases, you know, it's lawful or encouraged. So like Carolyn said, in the case of sexual and reproductive violence, restrictive practices and guardianship orders. Also, like Marley said, in addition to the gender drivers of gender inequality and ableism, intersectionality, so that all intermeshes within that as well. The segregated settings, like Carolyn said, such as group homes, hospitals, prisons, boarding houses, or settings on the street which don't neatly fit into that definition of family or domestic violence or intimate partner violence. That also fosters the environment for the violence to occur. So in my opinion, that's a driver as well. We need to look more closely at the environment as a driver, not just a setting. Often violence in segregated settings is behind closed doors and hidden. So the drivers of violence in those settings, I believe, still remains unaddressed and really quite neglected. When we're talking about human rights, so consistent with the recommendations from several of the human rights treaty monitoring bodies, our Australian government and the state and territories, we think that they should review, amend and repeal laws, policies and practices that don't comply with the CRPD. I really think that we can never, prevent specific forms of violence if the law is saying they're acceptable and we continue to have segregated settings. It continues to drive that. The United Nations conventions to which Australia is a signatory recognises that women and girls with disabilities have the same rights, human rights and fundamental freedoms. And Article 6 in the UN Convention, the CRPD, explicitly states that. So overall, I think unless we address that combination of the gender drivers, the ableist drivers, really embed the intersectional lens, like Marley said, not just have a 2-page document in major frameworks, and address the drivers of violence in our lawful settings, then we're really neglecting to comply with human rights conventions. It's absolutely vital that human rights frameworks are embedded across all aspects of primary prevention, or I don't think we'll ever fully combat gender-based violence for women and girls with disability.
Thank you. I'm going to have to keep an eye on the time because I don't want us to miss out on some of the things I know coming up that we need to talk about. But Marley, can I ask you about restrictive practices as a form of violence and abuse against women and girls in their family or their domestic settings?
Yeah, of course. So I guess, again, I want to come back to definitions. So I know the Royal Commission defines restrictive practices as any action, approach or intervention that has the effect of limiting the rights or freedom of movement of a person. And then this is very similar to how the NDIS defines restrictive practices. However, the way that WWDA conceptualizes restrictive practices is a lot broader and extends to interventions that are exclusively or primarily perpetrated on women and girls with disability. So the type of restrictive practices that I'm talking about include non-consensual and coercive sterilisation, menstrual suppression, forced use of contraception and forced abortion, the forced removal of children, denial of support for sexual activity and denial of support for intimate relationships. I also want to be clear that we're also assuming that restrictive practices include the non-consensual and coercive use of psychotropic medication. So even if this medication is prescribed by a medical practitioner for a diagnosed mental health condition, we do know that psychotropic medications are regularly used as restrictive practices to control the behaviour of women and girls with disability. In whatever context, setting, reason for use, WWDA very strongly believes that restrictive practices are violent and are in violation of human rights. I think there are multiple conceptual levels on which restrictive practices should be understood as a form of violence. So on one level, on the, I guess, very interpersonal level, the use of restrictive practices is a form of interpersonal violence against women and girls with disability because they're often non-consensual and they're coercive interventions perpetrated by an individual, like a split support worker, onto another individual that causes harm, takes away that person's autonomy, takes away that person's decision-making, and often, causes long-term and ongoing trauma. But most importantly, restrictive practices need to be understood on the structural level. And I think this is what WWDA has been advocating for a very long time, is that restrictive practices need to be understood as gendered ableist violence. And that understanding of ableism is really central to understanding restrictive practices because I want to be really clear, the use of restrictive practices, it's not just simply about stigma or negative feeling towards people with disability. Restrictive practices are part of a really larger project of maintaining specific hierarchies between able-bodied people and disabled people. We know as well that the use of restrictive practices is very severe and very commonplace in institutional and segregated settings. So coming back to that definition of family and domestic settings, that's why WWDA thinks it's really important to be considering places like disability group homes, prisons, psychiatric wards, hospitals, because we know in these settings, restrictive practices are often used with ambivalence every single day for organisational reasons. Restrictive practices are factored into how, for instance, disability group homes work and operate because they make it easier for support workers.
Can I jump in there? Because I think this links very closely to the question that I was going to ask Caroline next, which is WWDA's view about closed settings and about the optional protocol on the Convention Against Torture, the OPCAT as it's called. And when we're talking about closed settings, you would look at group homes as a form of closed setting. What's WWDA's view about OPCAT and whether you think that would make a difference for women and girls with disability in closed settings who experience violence and abuse?
Absolutely. I think one of the first comments I'd make is about the Australian government's apathy towards its obligations under OPCAT. We still have, you know, OPCAT, being a signatory to OPCAT means that that we require what's called national preventive mechanisms. So at a Commonwealth federal level, but also by each state and territory government to be established. OPCAT, it is clear from the text of OPCAT and Article 4.1 of the Convention Against Torture that that it's about being able to visit, monitor, review any setting where someone is deprived of their liberty, as in can't leave. Now, unfortunately, the national preventive mechanism at a Commonwealth level, the coordinating point is the Commonwealth Ombudsman, and it is very regrettable that we still have some states and territories who are yet to even work out how their national preventive mechanism is going to operate. I'm not an expert on where everything is up to at the moment.
No, I think my question was really reflecting that you take a very broad approach and you encourage a broad approach in understanding domestic and family settings, but particularly domestic settings, as you've said at the beginning. And so if we look at these requirements of the OPCAT, which is the opportunity to go in and visit and see what's going on and respond to allegations that
it's meant to be a proactive process, not a reactive process. It's a very important safeguarding process.
But you would like to see the principles of OPCAT apply in Australia, but also have a gender lens to them, so that incidents of violence and abuse for women with disability in closed settings is going to be picked up. Is that?
Yeah, absolutely. And it is very disappointing to see that the Commonwealth Ombudsman, the National Preventive Mechanism, has, or the Australian government, sorry, has only agreed to allow OPCAT to operate in what's called primary places of detention, traditionally like prisons and settings like that. Whereas from the consultation report and the Australian Human Rights Commission report released in 2020, that was a result of widespread consultation on the implementation of OPCAT in Australia, it was very, very clear that disability settings must be included, disability specific and mainstream settings where people with disability are often deprived of their liberty. So, and that is the position of the states and territories at the moment, who are setting up their, so there'll be no aged care. So residential aged care isn't included, group homes, other forms of segregated and closed settings. And I think that's really disappointing.
So you want to sort of see a broader view taken in terms of what the settings are to which the...
Well, it is an obligation under the CRPD, and it has been in Australia's 2019 review under the CRPD, it was specifically mentioned. The other thing is that I would like to say quite strongly is that there is a national advisory group, that committee that is set up, has been set up to advise on the implementation of OPCAT in Australia. It is very regrettable that there is no disability representation at all on that advisory group. And again, that's in breach of, Articles 4 and 33 of the CRPD. So that's a real problem, because we have a right to be able to participate and be engaged in decisions about our lives. And so even in those primary places of detention, there is overrepresentation of people with disability anyway. So is that answered your
Yes,
question?
that certainly has answered my question. I want to move now to where there are gaps in legal protections for rights of women and girls with disability in Australian laws. And I mentioned in opening on Monday the work the Royal Commission's done with an issues paper on violence and abuse of people with disability at home, and we've recently published earlier in March the responses. And WWDA provided a submission to the Royal Commission in response to the issues paper, and you identified a lack of consistent legal definition of violence against women and girls in state and territory legislation, and that then led to a varying degree of protection. We spoke about this at the beginning of this public hearing back in October, and you might recall Jacoba Brash, the then president of the Law Council, spoke about those definitions, and Ms. Ryan took us through the sort of hypothetical case of Lily, depending on where she lived, what her protections might be. So I don't think we need to go back and sort of cover the same things that we did in October, but in terms of what WWDA has been working on, I'm listening to women and girls with disability. You've called for the development of national legislation on gender-based violence against women. So Caroline, can I ask about that? But also at the same time is where can we look to in terms of other countries that have got an appropriate and comprehensive definition of domestic and family violence that may be something the Royal Commission might want to consider in terms of different models. Can I do those two questions in one?
I'll try.
Because I'm conscious of the time.
Okay. Well, first of all, yes, we have argued for a very long time about the development of national legislation on gender-based violence, because if you think about it, we have 8 different states and territories who define domestic family violence in different ways. And again, I'm not I'm not asking you to be a lawyer on this.
You. It's really just the importance of the protection.
I know I always say that to you. I mean, it is absurd when you think of it that in Australia, gender-based violence perpetrated against women with a disability in Tasmania may be completely differently conceptualised in law in New South Wales. We have inconsistent definitions. We don't even have a national agreed definition of what constitutes gender-based violence against women. And the reason that I say that is because the forms of violence we experience are excluded in law, in these acts many times. And we're just, and so why should somebody get a certain amount of protection in one state or territory, but not somewhere else?
Would you like to sort of see a national consistent definition?
Yes, but I think
there's a mechanism for doing that.
I did it again. I interrupted you.
That's all right.
Sorry.
I'm going to do protective interrupting so we can get through everything. But
now, we are a signatory to CEDAW, and in 2018, under Australians' review around our compliance, CEDAW has been calling for Australia to establish a national law on gender-based violence for a very long time. And in 2017, the CEDAW committee published a general comment, a general recommendation 35 to update the thinking around violence against women, and have given very clear authoritative guidance to states parties on what needs to happen and what we need to. So there are, so we need a consistent national definition that incorporates us, that includes the forms of violence that we experience and are at much higher risk of. So I know you asked about other countries. So it is, I wanted to point out just a couple of things. So the Istanbul Convention, which is 45 European countries are signatory to that. Now, one of the things about the Istanbul Convention is that it does actually name up things like forced sterilisation, sexual slavery, other forms of, gender-based violence. The South African legislation, there were 3 new bills introduced only a couple of weeks ago. It's not only about the definition, it's about the implementation. So, for example, the new law, South African law, has provision within it to, for example, to be able to apply for an apprehended violence order 24 hours a day online. So it's not just the definitions. The other thing is that if we look at the United States Violence Against Women Reauthorization Act, that again was only signed off a couple of weeks ago, one of the things that, and I'm not saying it's perfect by any means, but one of the things that that does is that it mandates things. So it mandates training of judges and, people who work in all sorts of fields. It mandates Native American women's rights. It mandates grants programs. And so it's a 5-year act. But for those 5 years, there's a lot of things in it that I think we could learn from. And again, I'm not saying it's great. The best one I would say is probably the Istanbul Convention.
So if we could look to some of
But
the
general
conventions.
comments, general recommendation 35, CEDAW, of which we're a signatory to, clearly spells out what the definitions and updates the thinking around what we mean by gender-based violence against women. And it includes things like our sexual and reproductive rights. It includes women with disability. So the definition's actually there. And so, and I guess the other thing, and it might be, well, I also wanted to say that how having national legislation is also about leadership. It's about this country saying, this is what we agree is gender-based violence against women, and this is what we're going to do about it. It is ridiculous to think that we have 8 different definitions and what constitutes a relationship and what constitutes, and then we also have, and then at the Commonwealth level, we've got a definition in the Family Law Act, and that's it.
So it's part of getting a national approach, but integrated in the sense that just sort of having a legal definition might not be enough, but how you support the protection of women, which is, as you said, training, awareness, funding, all of those elements that go into it.
Yes.
All right. Okay, I'm going to keep going. I've got to be tough on the time.
Sorry.
I
talk too much.
One issue is that widows raise concerns about lawful forms of violence. And, Rosemary Cayas has also spoken to us about lawful violence and the law sometimes as a tool of violence. This might arise in the context of guardianship, forced sterilisation and substituted decision-making. I think, as you know, we're planning on having a hearing later this year looking specifically at the issues of guardianship and substituted decision-making. Did you want to say something? I'm really going to go briefly on that topic.
Because, and I'll answer as briefly as I can, because to be honest, we could do a whole hearing on that.
We are.
Not just,
I think so.
Not just, but, the lawful forms of violence.
Yeah.
Now, how is it okay? How is it okay that we live in a wealthy country like Australia and it is still lawful to sterilise our young girls with disability and our adult women with disability without their full, prior and informed consent? How is that okay?
And we did talk about that.
Yep, so that's right. So it's not just forced sterilisation. How is it okay that in a wealthy country like Australia, we can forcibly make women with disability and girls with disability take contraception, and often injectable contraceptives that in some other countries have been banned years ago? How is it okay that we see our First Nations women with disability indefinitely detained without conviction? how is it okay that women with disability aren't allowed to have legal capacity? So I could go on and on and on about this for an eternity, but it is Australia's shame that to think that, as I said, it's 17 years now that every one of those treaty monitoring bodies, including the Convention Against Torture, the Committee Against Torture, has said, stop it. You cannot sterilise, stop the menstrual suppression, stop the forced contraception, stop the segregation. Until this country is prepared to address segregation, seeing people with disabilities as other, then we will never, ever stop this epidemic that is violence and abuse against women and girls with disability. I'm sorry. Is that too much?
No.
Right. Okay.
Law is one thing, policies and strategies is another area. And we've seen last year in December the release of Australia's disability strategy, a draft national plan to end violence against women and girls to replace the current plan. Caroline, and you might, if you want to share this with the others, it's up to you, but have the national policy approaches to addressing the experience of women and girls with disability being based on a shared understanding of what constitutes violence against women? I think based on what you've said earlier, all of you are shaking your head. I think the answer to that
really
might be no.
quickly for you, because no. And how can they, when we can't even agree as a country on what it is? So if we don't have nationally agreed definitions and conceptual understandings, how policy frameworks, and this is why national legislation is so important, because it's the legislation that sets the scope of policy frameworks, that then set the scope of funding and service responses. And it's that trickle down stuff. So if we look at just things like in the previous national plan, and I would say that we have worked very, very hard on the new draft of the national plan to reduce violence against women and children, but that is not yet released or
still in the drafting stage,
right.
Isn't it?
Yes. But in terms of Australia's disability strategy, we did the same thing there. We were very upset that we weren't able to get a standalone outcome area on safety and safety from all forms of violence. And it is problematic that we still don't have ways of even measuring properly. How can you measure something when you don't even have an understanding or an agreement on what it is? So, and the other thing I wanted to say is, it is from my experience, having been in this job for 25 years, that these policy frameworks that you talk about have largely focused on intimate partner and spousal violence. And even if we look at things like perpetrator intervention programs, I defy anyone to find me a perpetrator intervention program that actually includes and focuses on the perpetrators of the violence that we experience, or the other forms of violence. So perpetrator intervention programs are largely focused on, the intimate partner relationship. So we get excluded in so many ways because it's not well understood. The multiple forms of violence that we experience are not well understood. And so, yes, we're often excluded. So, and again, how can you have something, national frameworks that aim to reduce, violence, gender-based violence against women, when you have laws that actually allow it?
So sorts of issues of aligning the laws and policies together. But I think the clear message I'm understanding today is not to have narrow definitions that then will exclude disability, women and girls with disability, because they're outside those sort of mainstream senses of what relationships are for family or domestic settings. Is that right? Yeah.
And I think even something like a forced and coerced marriage. Now, typically in Australia, that's understood to occur in faith-based communities, when in fact that is a big issue for some women with disability. And And so, but it's never, there's no research, there's no interest. So we have so far to go. And so, yeah, I hope that's answered your question a
Yes,
bit.
it definitely has. So I'm just going to look at our timetable and say I'm going to press on for another 15 minutes or so. I think we've got a little bit of time, but I'll just check with those assisting me just to let others know that we might go on a little more. I want to come back to Marley and to Tess and turn our attention to the NDIS. And one of the issues which has come up for you in the work that you do and the women and girls who you engage with is an effective gender strategy within the NDIS. And so there is a concern from WWDA that there's not an effective gender strategy. Marley, do you want to take that question and tell us what the nature of the concern is and what needs to be done?
Yeah, of course. I might be a little bit cheeky and actually say, not only is there not an effective gender strategy, there actually is no gender strategy at all.
Right.
So I want to make that very clear.
So starting point is a gender gender strategy, and then secondly, you want it to be an effective strategy if it was there. Okay.
Exactly. So, you know, we know, I think the most recent participation rates in the NDIS that are released by the NDAA, it was 37%, sorry, of all participants were women and girls. Absolutely no data on the participation rates of trans or gender diverse people as well, which is important to point out. And there are heaps of reasons for this. So we know that women and girls with disabilities are often socialised and encouraged not to speak up for the support that we need. Different diagnosis processes. So for instance, for women and girls who are autistic, we know that they are way less likely to be diagnosed, therefore to be able to apply to the NDIS. And then there are lots of different types of disabilities and chronic illnesses that predominantly women experience compared to rates in men. And these are the types of disabilities that the NDIS doesn't consider. So all of these things kind of compound each other and ultimately, you know, kind of enforce this gender inequity within the scheme.
So what would a gender strategy look like for the NDIS? Has WWDA thought about that?
Yeah, so we think about it every day. So I think it's a gender strategy. It needs to include mechanisms to ensure that the processes to both access the NDIS as well as maintain funding, they're accessible to women and girls with disability, and that they are sensitive to the fact that many of us have experienced different forms of trauma. So, you know, for many women with intellectual disabilities, cognitive impairment, Aboriginal and Torres Strait Islander women in particular, there's a really specific risk of trauma associated with telling, for instance, a local area coordinator your story. So that needs to be part of an effective gender strategy for the NDIS. And there also needs to be some really clear supports related to health, in particular reproductive and sexual health for women and girls with disability. Because too often women and girls with disability were denied our right to sexual expression, and we're denied our right to bodily autonomy based on really ableist attitudes about disabled women being either hypersexual or asexual. And again, coming back to that human rights frame, the CRPD has said over and over again that women and girls with disability have a right to access services equally to everybody else. But unfortunately, that's not the case because the NDIS has not prioritised a gender strategy and hasn't seen it as important, which is really concerning considering the importance of implementing a really effective gender strategy to address things like gender-based violence.
Well, I think that we've got some representatives of the NDIA coming to give some evidence tomorrow. So that's a question I've asked them to think about, and we'll explore that with them tomorrow. Tess, can I ask you about what WWDA has heard about screening processes for violence in the NDIS, and are there processes or assessments in place for support workers or even for NDIA staff so that one might identify the issue. You were here in the hearing room when Nicole Lee spoke about this on Monday. Can I, that's a huge topic.
It's huge, and I've cut down what I've written to
Can
half.
we just, I think in some senses, could I ask you, and I know you've got some notes there, but it's really what, having listened to Nicole Lee's evidence and what you've heard during the week, I mean, what needs to be done in terms of this screening process, in terms of how WIDA's obviously heard a lot of stories from women on this. What needs to be done on the screening?
Yeah. Well, NDIS workers and staff, they're in prime positions to be able to identify when women with disabilities are experiencing violence. But we don't believe that they're currently equipped to do this effectively or properly. There are no, at the moment, substantial screening processes or assessment tools in place for them to use to be able to detect that. A standard question, you know, by an NDIS worker of, are you experiencing domestic or family violence, might not be useful for women with disabilities, because our experiences of violence are so broad, diverse, complex, and in different settings. And those sort of questions might not identify the more hidden forms like coercive control, or the restrictive practices, or things like, you know, restricting food or neglecting care. So we really think at WIDA that it's important that there's a regular routine screening process to detect this, whether that's during the application process, whether it's during planning meetings or coordination of supports or service provision or plan review meetings. So at any stage in that NDIS process. So we recommend the development and implementation of an NDIS violence assessment and response framework and or toolkit. And that would encompass what I think should look like identify, respond and refer. So going across all the levels. It can also, we feel strongly that if that framework and toolkit is going to be developed, it has to be with women with disabilities. So, you know, in co-design, they're not just making it for us and think that they know it's going to be okay. We scream about that all the time at WIDA. Don't make it for us, do it with us. And that toolkit needs to have that intersectional lens as well. When the development of the assessment toolkit is done, we feel that that should be made mandatory for NDIS workers, and appropriate training, like comprehensive training, not just an online module you go through at, you know, 1 hour at the end of your day, something that's really comprehensive. We also think that also along with the, you know, the mandatory appropriate training, is that we would like some consideration to be given to the establishment of a dedicated NDIS specialist disability gender-based violence assessment team who can do that as well. And overarching the toolkit and the assessment tool, like Marley said, we need the gender equity strategy that's overarching.
So again, that integration, that the gender strategy would also identify what screening tools might need to be.
Absolutely. So that's part of the whole process. It just doesn't, the assessment and toolkit shouldn't just sit as just this separate thing by itself. It needs to be addressed. The whole NDIS needs to have a gender lens.
And Marley, this fits into, I think, the question you were going to take, which is about the NDIS providing, or the NDIA probably providing, accessible information and resources to women participants about violence, so they can access assistance if and when required. What would you like to say about what needs to be done in terms of information and resources?
Yeah, so to date, to our knowledge, we haven't heard of anything being offered by the NDIS in regards to women participants about violence. And we would hope that this would be something that would be covered by a really effective NDIS gender strategy. Like Tess said, any type of accessible information and resources needs to be co-designed from the start with women and girls with disability and their representative organisations. And WWDA actually has some incredibly useful, award-winning, groundbreaking resources on safety and violence, including our site, which is a website that people can visit, that NDIS local area coordinators, for instance, could be promoting to their participants. There's also the 1-800 Respect Sunny app, which is similarly co-designed by and for women and girls with disability. And these are the types of resources that speak to our community, because they're the types of resources that actually reflect our stories and reflect our experiences. And I think one final part of the puzzle here is not just creating these accessible resources and information. There needs to be better integration between the NDIS and specialist women's services, because there needs to be really clear pathways for referrals. And yeah, the responsibility there is on the NDIS to be creating those pathways and understanding that addressing violence experienced by women participants in the scheme, particularly from NDIS service providers, is the responsibility of the NDIS. And therefore there is a responsibility to be able to not only give women with disabilities information on their rights on violence, but also to be able to effectively refer them on to those specialist services.
Thank you. Caroline, I was going to finish by asking you about the 26 recommendations in WWDA's submission to the Royal Commission's issues paper. If you're agreeable to the Royal Commission publishing that part of the paper, if we haven't already done so, they're very strong and integrated recommendations. So I'm just sort of mindful of the time that I'm not going to do justice to asking you about all of those recommendations today. But any final words from you, and we'll make sure that we can share, with your permission, the recommendations that you've made.
Absolutely.
So any final words, and then
yes,
I can see the chair's giving me a look as if to move it on. But
I will be brief, because
the chair is his usual benign self.
We can see you very acutely, Chair, but I'm conscious that the commissioners might have some questions that will pick up themes I haven't covered.
I guess as a final comment, and that'd be great if you could make those recommendations available. I would like to say as a final comment, I think, is that we can't, there's no such thing as a little bit of human rights. You can't cherry pick. You can't say, oh, well, we'll have that one, but not that one. As I said before, we have the framework in terms of the treaties, their general comments, their recommendations, our concluding observations, all those sorts of things. And that provides the framework for us, you know, to have a holistic response. So I think it's, you know, we want to see repeal of laws. We want that enable lawful forms of violence. We need to see an end of segregation in all its forms, and we need a transition plan. Not saying do it overnight, but, you know, we need that. And one thing that has, I would like to just quickly say, because it's come up in every hearing almost, is the critical role of independent advocacy. It is, you know, it is under-resourced. The model's not great. The funding model's not great. And I think that seems to have come through. I don't know if that's your impression, but it's certainly something that I think, you know, we really need to see much more focus on.
Can I will say, commissioners may be aware that this hearing has taken us almost a year to prepare. We've had the stops and starts, initially hoping to have this hearing in August, then October, and we start a little bit in October, and we're finally here. We're indebted to WWDA's advice and consultations with us along the way. suggestions for witnesses. And it's been a privilege to collaborate with you and for the assistance that you've given us to ensure that the rights of women and girls with disability who experience family and domestic violence can be heard, that we hear directly from women, but also for the support in bringing these threads together to help us understand what needs to happen in the areas of law and policy reform, and just reminding us of the importance of taking a strong human rights approach and how we do that. So I know that we could probably talk all day, but our discussions will continue not only in the hearing rooms, but outside the hearing rooms. And I wanted to thank you all, particularly Tess, who has come to lots of meetings with us, and we're really indebted to your support for the preparation of the hearing. Thank you, Chair. Thank you, Commissioners.
I'll ask Commissioner Galbally whether you have any questions or any comment you wish to make to the panel today.
Look, I'd just like to start by thanking you very much. It's so important that this hearing has become so central to us. So thank you so much for all your effort. I've got many questions, but there's so little time. But I did want to ask about the national policy instruments on the topic of violence against women and girls, and whether they include closed settings such as group homes, whether they're those mainstream policy, whether they're including closed settings too, because Tess, well, everyone really has identified them as being very important. So that's just one question. And whether you think it's possible to get that view in to them.
I'm happy.
Yeah, you go.
Well, obviously, we are represented on the National Advisory Group to develop the new national plan to reduce violence against women and their children. And I would just like to say how hard we have worked. And it's not out yet. It's not, but I am very, very confident and hopeful that those closed settings and that you talk about will be in there. Certainly we have fought very, very hard.
Yeah. And can I ask just a quick one more? And that's about the whole issue of sexual rights, especially. And I wonder whether you've got some thoughts about the greater risk to women and girls, because sexual rights aren't part of the agreement in Australia because they're often denied. And somehow that puts women and girls at much greater risk, you know, and whether you've got any comment on that.
So, Commissioner, are you talking about in the context of the national policy frameworks?
Just in general, that we've heard throughout this hearing and many other hearings, how sexual rights are almost often, you know, right on the back burner if they're at all. And then women and girls with disability become even more vulnerable because they're not addressed. And there's no attention given to that in terms of education, understanding, you know, anything to do with consent, like everything's sort of almost like it's like a vacuum. And I just wondered about the connection of those two, you know, the denial of sexual rights for women and girls, and then the much greater risk.
Yes, that's a very good point. And I think when I referred before to CEDAW General Recommendation 35, published in 2017, it actually makes very explicit around the sexual and reproductive rights violations, including denial of access to education, to information, to sexual and reproductive health services, as well as the things that I talked about, forced sterilisation, forced contraception, etc. And And it goes even further than that. It actually says that those can actually amount to torture, cruel, inhumane punishment under certain circumstances. And so that's why I would be really hoping that the Commission would take a really close look at that general recommendation, because it does give a more holistic definition, conceptual framework around what constitutes gender-based violence. And it does go to those things that you've just mentioned, Commissioner.
Thank you.
Lovely. Thank you. Commissioner Mason, do you have any comment or question?
Like Commissioner Galbally, I do have a lot of questions, but we ran out of time. But what I'm really pleased about is that WWDA given really incredible quality evidence today, and that First Nations leaders, particularly women, in the development of the national plan, in the work that is done with the Women's Alliances, it really sets a scene for important conversations. So this is not about anything to do with any surprises. WWDA has really laid out a very clear clarion call for change. So I'll leave that there, and I just want to say thank you, and particularly to Tess for your leadership. It's been really invaluable and timely. Thank you.
Thank you. Commissioner Bennett, do you have any questions or comments?
I just want to say thank you as well. And also I found your response to the paper in the 26 recommendations, and I'm glad that they're going to be available for others to see as well, because it's important to get that information out. And just building on Rhonda's, we've heard so many times today and yesterday, I think probably also from slightly older women than Marley, but about not knowing, not feeling they had rights in the sexual violence, and hopefully the reforms can be made so that it doesn't go on to another generation. And thank you.
Thank you. Let me reiterate what Ms. Eastman has said and endorse her comments about the contribution you have made to the preparation for the hearing and for this session. One of the things that has really been quite remarkable actually this week is the range of issues that have been addressed within the framework of domestic, family and sexual violence, and clearly the issues that have been addressed and the way they've been addressed owe a great deal to the contributions that WWDA has made to the organisation of the hearings. And that no doubt will be the subject of comment later on as well. But thank you very much for that, and thank you very much for presenting your ideas so forcefully and clearly today. Thank you.
Thank you.
Thank you, Chair. And thank you for everybody with a little extra time. As I said, we could probably spend a whole day in discussions, but our discussions will be ongoing.